Hi, and welcome to our first virtual talk on IP and competition law. I'm Stephanie Wickenden, a barrister at Court Chambers specialising in IP, and I'm virtually here with Suzanne, who's also a barrister at Court, and she specialises in EU and competition law. She's also a professor of IP and competition law at Brunel University. This is the first of a short series of talks which we want to present to you, with Suzanne and I discussing issues at the interface of IP and competition law. And the idea for this series came when Suzanne and I were having a chat about trademark registrations, and in particular the recent SkyKick CJEU ruling. And we realised that in a lot of our practice, we actually deal with similar issues, which is coming from completely different perspectives. And then there was a huge scope, particularly in the field of trademarks and other IP rights, for competition lawyers and IP lawyers to work together to come up with some new and innovative perspectives. For those of us who are IP lawyers trained in the UK in particular, we're very much raised with the concept that there is no such thing as a general law of competition in the UK. And often our clients, particularly those who are IP right owners, think of competition law as a hurdle or something that they've got to be careful about. So certainly for IP practitioners in the UK, we don't necessarily think of competition law as our friend. But it seems to me from discussing with Suzanne that this is potentially a big missed opportunity, and there could be a huge benefit of taking a new competition approach to cases, and in particular in the field of trademark registrations, where there's a SkyKick type issue. So we wanted to share our insight with you, and in part one, we're going to be considering the SkyKick case in particular, and whether a competition law approach could come up with a new way of getting through the clutter of trademark registrations that has been bothering the IP community for a while. So before going into those particular questions, obviously if you're a trademark practitioner, SkyKick needs no introduction. For our competition law colleagues less familiar with the case, there is a very quick summary on this slide. If you'd like a more detailed view, I'd recommend the various posts available on the IP catalog. For this video, the key issues are the questions referred to the CJEU set out here. The court's answer to the first question was quite conclusively no, if what is relied on is a lack of clarity and precision. However, the court left unanswered wider questions of public policy relating to overreaching registrations. On the question of bad faith, the court said a lack of intention alone will not be enough. But if that intention is coupled with other anti-competitive motivations, then yes, bad faith could be made out. So I'll now hand over to Suzanne, who will give us a little introduction on the principles of competition law that we're going to be discussing further in our video.
Thank you, Stephanie. Historically, there was a view that IP and competition law were in diametric opposition to each other, with IP creating monopoly rights and competition law existing to open up markets where exclusivity was the absolute antithesis of a free and open competitive market. Over time, it's fair to say that view has become much more sophisticated, and the prevailing view sees IP and competition law more as complements than as in direct conflict. So if we see the two as protecting or promoting long-term or short-term competition, we can perhaps see how they can sit together. So on the one hand, IP law rewards innovation. It grants rights to exclude, whether it's a patent, the duration of the patent, or copyright for the life of the author, plus a certain number of years depending on the jurisdiction. And in that way, the idea is that brand owners, creators will be incentivized to invest in the IP, which in turn promotes long-term dynamic competition. But at the same time, the competition laws operate as a backstop, as a mechanism to sanction anti-competitive activity. And what I'm talking about here are the competition laws under the Treaty on the Functioning of the EU and their national equivalents. And these are aimed at sanctioning anti-competitive behaviour. And the aim is that whilst these laws are not there to correct for the impediments in the IP system, they do protect long-term dynamic competition, because there is a danger that as monopoly rights are created, that can give rise to market foreclosure if those rights are abused. But defining the exact boundary as to where competition law can step in has been one of the most difficult questions in the so-called IP competition law interfaces, which I'm presented with in a lot of the cases I deal with. So just a reminder of the basic competition law provisions that we're concerned with here, which broadly segment into two categories. There are restrictive agreements, which are sanctioned under Article 101 of the Treaty on the Functioning of the EU, or national equivalents such as the Chapter 1 prohibition in the UK. And Article 102, which deals with abuse of a dominant position. And what is particularly relevant for present purposes is that in circumstances where the IP owner is accused of having breached competition law, if it's engaged in a unilateral practice, i.e. there is no agreement, essentially the tool for sanction is under Article 102, where it is first necessary to establish that the party is in a dominant position at all. And if that's not established, then Article 102 has no role to play. If it is in a dominant position, then consideration needs to be given as to whether the relevant practices, here trademark registrations, are abusive. And while the EU treaty sets out examples of illustrative abuses, such as very low pricing, excessive pricing, and there are examples in the case law such as refusal to license IP rights, those categories are not closed. And what that does is it does provide scope for claimants, for competition regulators to use the starting principles under Article 102 to sanction practices which are more novel and have not been encountered before. And that's particularly what we see in the evolving case law on Article 102 and on the interface between IP and competition law. So I hope that's helpful just in mapping out the territory for those who may be less familiar with how these two areas interact.
Thanks, Suzanne. So my first question for you is going to be on the 102 type provisions. So the CJEU has confirmed in SkyKick that the absolute grounds of invalidity are exhausted, and that a wide registration alone is not going to constitute bad faith or which will affect public policy. But this is very much from the perspective of looking at an individual registration and what that specification says. It doesn't look at the wider picture, as you say, dominant position in the market, whether that's overall abusive. So could the practice of accumulating trademarks, particularly a wide series of them with a very wide specifications, be an infringement of competition law?
So, as mentioned, the starting point is that the party registering the trademarks needs to be found to be dominant in a relevant economic market. And the mere fact that they own a trademark or have other monopoly rights over IP does not of itself equate to dominance in a relevant economic market. So that's the first thing to establish. So let's say, for the sake of argument, that the party registering the rights is found to be dominant in a relevant market, which could be an IP licensing market, it could be a downstream product market in respect of the goods where those trademarks are incorporated. So let's just put that issue to one side. This issue did come up in an analogous context in the European Commission's pharmaceutical sector inquiry. The focus of that inquiry was very much around the patenting practices of major pharmaceuticals. And a question was raised as to whether the creation of so-called patent thickets, where there were multiple patent applications, patents on the register, whether that may operate as a barrier to entry and disincentivise new entrants, particularly generic or new innovators who wanted to invent around. And one can see that there is something of a read across into the trademark space here, where an argument could be raised that the strategic creation of the so-called trademark minefield, where it's very difficult to navigate those multiple registrations to work out whether in fact you do have a registrable right at all. What I would say, though, is that in the course of that inquiry, although these issues were very much brought to the fore, they did not result in an actual finding of infringement based on the mere fact of accumulating vast swathes of patents and applications. And I think where this leaves us is that these ideas, these concepts have given national regulators some inspiration perhaps as for practices which could potentially be problematic. But to date, there is not yet a concrete case where the mere fact of creating this system is seen of itself to be abuse of a dominant position.
So yeah, I mean, patent thickets and comparing that to trademark cluttering is something Suzanne and I have been talking about. So my second question for Suzanne is there a competition law remedy available to prevent parties registering broad trademarks they don't intend to use?
Well, there is an interesting dichotomy here, because in one respect, what the owner of the right is seeking to do is to use the IP regulatory procedure to secure a right which, if accepted, it is entitled to earn. And let's face it, when applying for registration or for patents, in the same way as pursuing litigation, it's never a slam dunk. We can't always be assured that we would get the result that we want. But there are some analogous cases where parties have pursued regulatory procedures, where there has been an IP interface, and where that is done by a dominant company in a way that makes new entry more difficult, that has been sanctioned under competition law. The so-called abuse of regulatory procedures cases. And again, these come to mind most prominently in the area of patents and in the area of pharmaceuticals, with the case of AstraZeneca, which was probably the most seminal case here, where the European Commission fined AstraZeneca initially €60 million for abusive regulatory practices in effectively misrepresenting its case to a drug approval authority. That was abuse number one. And secondarily, a practice of withdrawing its patents, its goods from the market, so that new entrants did not have a reference product so that they could bring on board their generic supplies. That was a practice that they were perfectly entitled to do under the relevant regulatory procedure, but it had the effect of prolonging the life of the existing registrations and approvals. So anybody wanting to invent around this and develop their own IP rights had to effectively start from scratch again because of the absence of that reference product. Reckitt Benckiser, another case in the United Kingdom, this time by the Office of Fair Trading, which involved a similar situation of supply of a second generation product and withdrawal of the original product from the market, with the result that generics coming in found it much harder to get recognition for their product because effectively the market was being moved to the second generation product. So these are examples of cases where an IP owner, using its rights under regulation or IP law, is found to perhaps be playing a little bit fast and loose with those procedures. And because of the special responsibility on a dominant company, those are practices which have been sanctioned and are emerging with increasing frequency at national level. And we see cases in the UK as well. What I would say with regard to the issue of non-use is particularly in recognition of the fact that the provisions as to use in different trademark registration systems do mean that there are opportunities perhaps for some gaming of the regulatory system depending on where the trademark is registered. So, for example, it's an inherent part of the trademark application process in the UK and some other countries that you will declare ex ante intent to use the trademark. So there is perhaps analogy there with the AstraZeneca case around perhaps misrepresentation to a regulatory body as to one's intentions or one analysis as to the legal position. If we contrast that with perhaps some of the Benelux countries, where the applicant is on notice of putting the mark into genuine use within a 5-year period on pain of revocation, but in reality, because that is an ex post sanction, it does create concerns as to what market advantages gained in that period and whether that operates as a strong message to others who may want to register a trademark that is similar to stay away. In the United States, again, something more of an ex ante evaluation of use. So again, because of that patchwork quilt of different protections on the issue of use, one can see that there are opportunities for some strategic manipulation that could form the part of a potential abuse of dominance in the right circumstances.
Yeah, it's that was one of the referred questions to CJEU on SkyKick, particularly this relationship between intention to use and bad faith. Bad faith obviously being a ground of invalidity, absolute ground that would invalidate a registration from ab initio, rather than having to wait for 5 years of non-use. So, obviously in the UK, we have a system where you have to register a mark, and when you make that registration, declare an intention to use. But that's not present in other countries, and it's not present in the EU trademark system. So we do now have some guidance from the CJEU, from SkyKick, on the relationship between lack of intention to use and whether this is in itself rendering an application made in bad faith. So the CJEU said an application that's just registered without any intention to use in itself is not in bad faith, but it may well be if the applicant for registration of that mark has the intention either of undermining, in a manner inconsistent with honest practices, the interests of third parties, or they're trying to obtain a right, an exclusive right for purposes other than those falling within the functions of a trademark. So how does this ruling fit with your understanding of bad faith more generally as a principle of competition law?
So this is very interesting, and from an abuse of dominance perspective, the starting point is that Article 102, national equivalents, are of general application, and we see this expanding scope of that principle in the regulatory procedures cases and in the application of competition law to IP rights. But it does not necessarily follow that the characterisation of a concept of bad faith for the purposes of one area of law are necessarily mirrored in competition law. So in the same way as a tax treatment of a relevant product market doesn't necessarily translate into an economic market in competition law, similarly the notion of a contract under commercial law is not the same as an agreement under competition law. So this opens up the possibility of notions which are peculiar to competition. And there are certainly signs in the case law of the obligation of good faith or the obligation not to engage in bad faith practices having a much more pervasive role. The European Commission has accepted a principle that a dominant company must deal in good faith. In a case in the postal sector, another monopoly supplier here, that related to its contractual negotiations with a new entrant. But it's easy to see how that higher responsibility of good faith could permeate other aspects of Article 102. In the UK, there is a case, it was an interlocutory application involving T-Mobile seeking an injunction actually requiring T-Mobile to switch on the approved numbers of a new entrant operator. And in that case, the judge was very critical of the practices of T-Mobile in playing fast and loose, buying for time, making life very difficult for the new entrant, and whether one can extrapolate from that a much wider principle that there is a duty on a dominant company at least to behave in good faith in its dealings with newer entrants is something which hasn't yet been fully tested, but could certainly well be argued based on the principles that have been emerging.
Yeah, I mean that's interesting, and also gets into my next question. I mean, we've got the CJEU ruling on bad faith. What we don't have is any further guidance on broader principles on the basis of public policy and trademark cluttering. I mean, then that was argued in SkyKick. That was one of the arguments that there's also an absolute ground that a trademark must not be contrary to public policy, but there's very little guidance on what that actually means. We only have the guidance from the CJEU stating that it refers to the application itself. So sort of clarity, even if something's not clear and not precise in terms of specification, that's not contrary to public policy. But what we're really talking about, and what the trademark profession wants more clarity on, is whether sort of the practice of deliberate cluttering would in itself potentially be contrary to public policy and therefore invalid. So do you think that competition law breaches that we've talked about could be used to argue that trademark specifications are contrary to public policy? And would this maybe encompass situations which are a bit broader than those which would fall within the CJEU definition of bad faith?
So the interesting question here is perhaps whether could a breach of competition law of itself, by virtue of being a breach of competition law, be offensive to public policy and therefore a ground of invalidity? And as the starting point, we can say that it's accepted that competition law or very specific sector regimes or regulation, these regimes, they exist in their own individual silos as parallel processes, not necessarily as though one trumps the other. So there are many examples of cases where a practice by a dominant company, particularly in the telecom sector, may well be compatible with telecoms regulation, but could still be a breach of competition law on a standalone basis, which gets you to the same result of making that practice unlawful, albeit by a very circuitous route. In the same vein, though, the mere fact that a practice violates competition law doesn't necessarily ipso facto make it a violation of another area of law. And there are ample cases illustrating that in the case law on Article 102. But what I'm particularly interested in is the idea, perhaps, of competition law as an overriding rule of public policy that cannot ever be derogated from in appropriate circumstances. And perhaps a hint as to where this could potentially go is an example in the arbitration sphere, where I have both anecdotal and actually public reported cases where parties have raised as defences to allegations of breach of contract that the other party's behaviour or practices infringe competition law, and that if the tribunal effectively gave a remedy, it would be to bless that breach of competition law, which would be repugnant to public policy. And there is a case going back to 1996, which is reported, where in this instance EU law was relevant. The contract would have had performance implications in an EU member state, in Germany, but interestingly it was governed by New York law. The seat of the arbitration was Geneva, so there were many jurisdictional aspects which took us away from the EU arena, but nevertheless this idea of giving a remedy to a party in circumstances where to do so would be effectively blessing a competition law breach was seen to be a step too far for the tribunal. Now, I appreciate when a trademark body is assessing an application ex ante, it probably does not have the resources or bandwidth to assess any potential competition issues at that stage. But here again, we confront the issue of perhaps potential gaps in the law where these arguments could well be raised in a different forum, whether that's part of settlement negotiations with the other party or otherwise. But there is certainly the seeds of ideas in analogous areas of law.
Yeah, I mean, it seems already open in the absolute ground of invalidity that a mark must not be contrary to public policy, that you can run those arguments. And obviously the office is not going to do an ex-ante assessment of all potential competition law breaches, but certainly if there is an application for invalidity of a registered mark on the basis that it's contrary to competition law, it would be very difficult for the office to uphold the validity of that mark in circumstances where it's a breach of competition law. So maybe that's another question that we're going to have dealt with at European level at some point, but maybe a missed opportunity in SkyKick. So we've already talked a little bit about the kind of procedures that are available, but just the final question for you, and to put everything together, is if a party is faced with infringement proceedings like SkyKick, where you're facing very broad registrations, you think there could be an argument that it's anti-competitive, what do they do about it? What procedures do they need to take, and what would the remedy be?
Well, faced with those opportunistic strategies, there are a number of different remedies that could be considered, and they fall into two camps. There are the public remedies, which involve a complaint to a competition authority, whether that's the European Commission or a national authority such as the Competition and Markets Authority, or pursuing a standalone competition action, whether that is in the High Courts or the Competition Appeal Tribunal in the UK, which is a specialist body dedicated to dealing with competition issues. More often than not, these measures are pursued in parallel, which creates an interesting dynamic in terms of trying to settle these types of cases. And speaking anecdotally, in my own experience, the vast majority of these cases do settle because of their confidential nature. They are not typically reported, but I do have examples, at least in the trademark area, where claims along similar lines to the ones that we've been discussing in this talk have been raised before a European competition authority, came very, very close to opening proceedings, and the issue was resolved inter partes through a commercial arrangement. As between those different options, the advantage of a complaint to a competition authority is very obviously in terms of costs. After having produced your complaint, you can decide how involved you wish to be or not. The regulator has access to documents through its own regulatory powers in a way that, as a private party, you would not do. But at the same time, a competition authority will decide its cases based on administrative priority. In the absence of any pan-European issues, it's very unlikely that the European Commission would take an active interest. And there is a real question as to how long you can wait. If you're not able to get interim relief, which can be very rare, then the question is the market has moved on by the time the remedy is forthcoming, if at all. And for that reason, it's focused the attention of claimants, particularly in the area of private antitrust actions, which are burgeoning on a standalone basis. And by standalone, I mean an action that is brought in the absence of a decision by a regulator finding an infringement. So this is a pure individual claim before a court or the Competition Appeal Tribunal. The advantage of a follow-on action is obviously a finding of infringement by a regulator that the litigant can then bring in front of a national court, and that will be proof of liability, which means that the whole debate becomes a debate about remedy in that instance. But in these trademark cases, IP cases, what a claimant will ordinarily be seeking is not so much damages, but a form of injunctive relief or an agreement not to sue them. So the injunctive nature of the remedy will be much more important. So there are varying moving parts here. In practice, in my experience, it's having a range of options which has strengthened the case for those claimants that want to bring such a case. On the defence side, and recognising that many of our listeners will be on the receiving end of some of these allegations, from their perspective, having a very robust case on dominance, relevant economic market, and whether the very practice itself is abusive, is where investment should be devoted to trying to defend some of these actions, some of which may not be meritorious. And I go back to the starting point of my comments earlier, that there is a fine balance between using competition law strategically to protect long-term competition, but also recognising that competition law is not necessarily there as a mechanism to fill in the gaps, where perhaps we may need to look more critically at some of the imperfections in the IP registration system itself.
Thank you very much, Suzanne. That's my last question for this part. Thank you very much for watching, spending some of your lockdown time with us. We hope you found it as interesting as we had to consider these different interfaces of competition law and IP. In part 2, we'll be shifting the focus from registration to infringement, and we'll also be considering what will happen after Brexit. So we will be using the dreaded B word, I'm afraid. In the meantime, if you'd like to contact either of us, please do. Our contact details are up on the slides now. If you've got any questions for us, if there's anything you'd like to see in one of our next talks, we'd love to hear from you. We will likely be at home. Thank you.